Thank you for standing by, and welcome to today's webcast. Are you ready for GDPR? During the presentation, all participants will be in a listen-only mode. Please note you can expand your slides by grabbing the arrow in the bottom right corner. I'll now introduce Sarah Isle, who will introduce today's topic and speakers. Please go ahead, Sarah.
Welcome to the webinar, everyone, and thank you for joining us. As a reminder, this webinar is being recorded, and we will be sharing the recording with you after the event. Also, we encourage you to ask questions during the event via the chat box. Our speakers for today are from Digital River. Joining us today are Christopher Rentz, Chief Information, Data Security and Risk Officer, Thomas Hamilton, VP of Compliance, and Dr. Kirsten Lieneman, Director of Legal EMEA. Digital River is commerce with accountability. That means we're all in, 100% committed to commerce and our clients. Our advanced Commerce Cloud, monetization tools, and global services are set up to give online businesses an edge and risk-free entry into markets worldwide. Today's webinar topic covers the General Data Protection Regulation, GDPR, the regulation reflecting the need for increased privacy for European residents. The new regulation was officially adopted in April 2016, and enforcement will begin in May 2018 after a 2-year transition period. I would now like to turn this conference over to Thomas Hamilton.
Thank you, Sarah. So we'll start with giving a little bit of a background regarding GDPR and where it evolved and how it was established. So it isn't something that is entirely new to the European landscape. The European Parliament back in October of 1995 passed EU Directive 9546. The GDPR is an evolution of EU Directive 9546 rather than creating an entire new framework in itself. It's an evolving legislation in that it has some of the similarities of the EU Directive, but it has enhanced enforcement mechanisms as well as some more robust scope. It also takes into account a lot of the technology changes that have occurred from 1995 to the current date. The main benefit of GDPR, while we're looking at a lot of the additional risks that it may present, the increased benefit is that it creates harmonization across the EU, in that instead of having different legislation that enacted and incorporated EU Directive 9546, we will have one framework legislation that will apply to all member states. The reason that Europe is taking such a robust view of the GDPR goes back to the fact that they conceive of personal data as a fundamental human right, which is in contrast to the United States, which views it as a commercial commodity, and therefore has provided enhanced protection to people who have the data and their ownership of their own personal data. The GDPR really takes into account two key tenets. The first is the fact that customers are becoming increasingly mindful of who is accessing, collecting, storing, and processing their data. It also takes into account the advancements in technology that have occurred over the past 20 years and new ways that companies and individuals can use their data and in ways that people are exploiting the data now that were not necessarily conceived of back in 1995. As a result, the European Parliament and Council introduced the GDPR, which forces businesses to adapt practices into this evolving area and to create more stringent regime for managing data that is within their possession in order to protect the individual consumer. So kind of here we'll go from a high level of what is GDPR and who is impacted. What is GDPR? It sets strict rules for protecting personal data of European residents. It also applies to non-EU citizens when they are doing business in or traveling within the EU. So if you are a resident of the state of California and you are on vacation in Germany, the EU GDPR will cover the protection of your personal information that you disclosed while you were in the EU. The GDPR, as Sarah previously stated, becomes enforceable on the 25th of May, 2018, and the legislation was passed back in April of 2016, as they did give a decent 2-year ramp-up time for corporations and individuals that hold personal data of consumers and of citizens of the European Union time to get established measures in which to ensure compliance. The GDPR, the key thing to remember here is that it gives individuals greater control over their personal data than ever before. This also means, in contrast, that it means that there are additional requirements upon businesses handling that data. The easy answer to who is impacted is every business. Anybody who processes data, regardless of their geographic location, is impacted. It applies to all forms of processing, including marketing, employment, e-commerce, information security, customer service, business-to-business sales, as well as many other usages of personal information. So by no means an exhaustive list, but just a list of several types of examples. A key wrench in the works here will be Brexit, which is anticipated to occur sometime around March of 2019. Between the time that GDPR becomes enforceable on 25th of May and the time frame in which the UK leaves the European Union, the UK will be under control of GDPR and it will be having to adhere to it fully. After Brexit occurs, and because of the trade relationships between the United Kingdom and the European Union member states, it is likely that the UK will establish their own regulation that is similar in scope to GDPR. It will have several nuances that are unknown at this time, but it is likely that as long as you create a regime that establishes the UK data in the same way that it handles European Union citizen data, that it will be the best course of action for you to take in implementing a GDPR strategy. Bottom line, GDPR gives residents more rights and responsibilities over the data and less controls to organizations, including businesses and people selling to those citizens who want to use that data. So the key question that comes as a result is whether or not your company is ready for GDPR. And that's the intent of our educational session to you today. The first of all is that when surveys have gone out and asked how people are going to look at GDPR and whether or not they're going to be spending more money to meet data protection requirements as a result or not, it's overwhelming. 70% have stated that they're going to increase their budget in order to meet the data protection requirements. And 30% expect their budgets to rise by more than 10%, which is a significant material deviation from their standard budget. And one of the reasons that they're investing these resources, their time of their individuals, as well as monetary investment, is because of the fact that the fines are so significant. Businesses that are found not to be fully compliant can face 4% fines of their annual global revenue, not just revenue that is within the European market, but their global revenue, or 20 million euros, whichever is greater. And this can occur on an annual basis every year. It isn't just a one-time fine. You may be fined multiple times if you remain non-compliant from year to year to year. Furthermore, and even more impactful for businesses that provide e-commerce as well as providing software and hardware solutions generally, is that a company can be found to be forced to discontinue business in Europe in its entirety and be basically banned from the European Union marketplace. And that is a significant risk to any company. It is a similar risk that you can see if you have, import-export trade restriction where you cannot trade into the European Union. It's similar setup and penalty as that. And in addition, you risk losing your consumer trust and brand image if you are found to be non-compliant, because as with the EU directive enforcement actions, these enforcement actions are likely to be highly publicized. Another item to keep in mind is that the entities that are enforcing and managing this structure are 100% self-funded, in that they are receiving, their employees and their operations are entirely funded by the fines that they are implementing and enforcing upon others. So it's similar to how the United States Patent and Trademark Office is, whereby they don't receive separate funding from the European Union or its member states. They are instead receiving funding based on the fines that they are levying against businesses and individual organizations that are found to be non-compliant. So no matter how you look at it, it's critical that everybody takes a look at the GDPR and has a game plan for the GDPR in order to remain successful. At this time, I'd like to pass it off to Christopher Rentz, who's Digital River's Chief Information Officer, and data protection officer to go through a guidebook and a playbook that we found to be a good guidepost when looking at how to get yourself ready for a GDPR regime.
Thank you, Thomas. Good morning, good evening, good afternoon to everyone. So one thing that I wanted to outline for everybody to think of is for GDPR, put it into context as this is something like a Y2K event. So when you look at understanding GDPR, there is a lot of data out there. So look at, take time to understand the GDPR. So go out and look at the EU regulations, go out to the EU websites themselves, reference the EU Council documents. So really understand where the facts are coming from, because there's a lot of interpretation out there. The other component of this is ensuring that you have full sponsorship from your executive leadership. This is not a one-time shot program, as Thomas had pointed out. This is every year, every involvement, you need to look at all of your technologies. Understand how it impacts your company and what's in scope for your company. Understanding how the EU is looking at data subjects that go along with that. Understanding the flow of how your data is going from internally your company between your other divisions and how third parties. And, understanding, who is ownership of this. So it's really trying to work through that this is a program. So have a program manager assigned, have your data protection officer assigned, because this is going to be a living process within your company, especially as you evolve as time goes on. The basic privacy principles that go along with GDPR is really looking at how you understand how you're using the data. So if data is coming into your company, how are you storing it? Making sure that you have limitations on that. How is it being used by others? Consider each of these areas. So think of your data retention policy, understanding how you need it, and make sure those policies and procedures are in place. So when you look at the GDPR websites, go out there and look at the facts and the capability. What are the checklists that you need to follow? Because there are a number of items that you need to have in place that will be a part of audits in the future, even internal audits that you would have from your internal audit company divisions, also your third-party audits if you're using a third party such as KPMG, Grant Thornton, any of the major ones that are there. Controller and processor is really understanding how do you own the data. So if you're I'm a data subject, that would be me, and I would have my data. You're using my data, so you are the controller that I'm giving it to. So you are the individual that's understanding my data, how it's being used. Then you're providing it to a processor. So you may be taking my data and giving it to somebody else to process so that they can provide an outcome. That outcome may be a mailing campaign, that outcome may be logistics that's sending you a product, that outcome may be something you're doing in a manufacturing process. So you really need to understand how the controller and processor and all the steps along the way. So how are you using it? And a big component of this is from how are you ready that if there is a request from a supervisory authority, how you're going to be responding to that. The lawful processing is really understanding the business impact. Why do you need my data? How are you going to be using my data? How are you ensuring that the contract that you have between me and you are in place? So what are the policies and procedures that you have on your website? Even if this is just a physical purchase that's coming through a catalog, this is not just defined to the internet processing. This is defined to any way that you're collecting my data. And then GDPR, one of the things that's not on here, but to think about when you're looking at the requirements is the GDPR reach. So GDPR has 28 member states when you think of the EU, but there are also 47 member states that does not include the U.S. that basically are part of the EU Council. So these are other countries, provinces, other things that are related to the EU or the EU is doing business with, and they have basically worked through to whitelist that these countries, provinces are meeting those requirements. So basically looking at what is the data subject, the access right. So a data subject is me or as an individual. So how is the controller, you, as your company providing that? What are the access rights? When I contact you, what are the procedures and processes you've put into place that if I asked for my data to be erased, what are the processes you're taking for? If I ask to edit that data because something's changed in my life, even where I am, what it is, my address, those sort of capabilities, Export, so if I would like all of my data packaged up and then sent to me, what are the export processes? That has to be done in a standard format that can be imported by another company or another process or me specifically. Restricted, basically, what are the areas in the data points that are being restricted that I can't use as a company based on my requestions? And then object to processing thereafter, so basically if you're making a decision, how do you make that decision? So if you're using something like an automated process to make a decision on my data, then I would be having the option to request that that be done by a human, not by an automated process. Basically, processing children's data. This is extremely important. So, and this is important everywhere around the world. This is protecting our children. So this is really understanding how your business is collecting children's data. Ensuring that if there is a website, if there is a request for a child, that what is that information? So within the EU, the average age is 13 for the standard, but each of the 28 member states can adjust that, and that standard in age can be up to 21 years of age. So when an individual's on your site, they are collecting that, and you are collecting that information, ensuring that you have the consent process from a parent or a guardian, and that you are flagging that data because that data cannot be retained and reused. So you need to have your policies and procedures to support that, and that will continue to evolve. So something to keep very, very close eye on. Updating your privacy, security, incident response policies. So these are the things that go along with GDPR. So looking at the regulations and a number of the articles that are associated with that is how do you respond? So if a company were to have a breach, what is the process? So think of it this way, is that everybody talks about a breach and an incident. So an incident basically is that there is a problem that I've identified. I'm going and collecting all the information on that, and from that I'm going to make a decision as to how to respond. A breach is a technical component in the sense that the IT group has identified this. They're using all their technology capabilities to contain that and support that down. And then cross-border data transfer. One of the big components of the cross-border data transfer process is making sure you understand how the data is being handled. So this would be between your primary entity and secondary entities within your company, so that you have contracts in place between that for data transport if you're transporting data to a third party. And then also if you're transporting that data, so even from the data subject's request, if my request is to have that data bundled up and sent to me, that your cross-border data transfer processes and policies are in place for that also. So contractual requirements. So these are the things to ensure that all of your contracts and all your legal T's and C's incorporate the GDPR requirements. So as you're looking through all your languages and processes that go along with all your contracts, and capability, ensure that when you're working with your legal department, in your sales department, and your third parties, that you've included that into all of your contracts and clauses. And these are things that need to be evaluated on an ongoing basis. Security measures is really working with your security team. So if you think of all of the things that you do for PCI, all of the things that you do for any of the industry audits, those all build on to all of the capabilities. So think of it as a wedding cake. You have a baseline of all the security you're using within your company. You have the notification processes that are built on top of that. So they would be all the standards that go through that. Because when you do define a breach, so you have an incident as we talked about before, the incident is so I can go through and understand what the impact was. After you've decided that it is a breach, then you have 72 hours to report this out. And when you report this out, it's ensuring that you have all of the data that's required to support that request. And so that any of the questions that come back, you have that all set up. So make sure your policies, your procedures, your documentations, you've worked very closely with your legal department, as when you post that information, you need to make sure that you can follow up with all the details that go along with that. Privacy by design, this is, and by default, is working with your development teams, really understanding that it isn't just that I already have a product out there, I don't need to go back and remediate it. You do need to go back and remediate. You need to look at what your products are doing when you're in your development phase. What are you doing for, capturing information? Is there code that's basically capturing PII information just because it's writing it to a log because it's easier? These are the standard business processes that you need to work through, but you need to work very, very closely from your development organizations, your web dev organizations. If you're leveraging third parties to do development, they are a part of your flow down. So you have to understand your entire ecosystem as you're doing all your privacy by design and by default as you work through that. Large-scale monitoring is another component of this, is really understanding what are the processes that you have in place. So what do you have from your standard processes of your monitoring? What do you have with understanding all the data that's coming through in your system? How are you understanding how your pieces are? One of the big things that comes out of GDPR as you're working through it is understanding how your marketing department is using your data. This is a big component of it because you'd have all your processes, but if they are ingesting data that is collected from your processes of a company, your third parties as a process, if they are buying information from a third party that includes my data as a data subject of the EU, you have to ensure that you understand that and that you have consent to be able to process that. Also, is that data being destroyed in a repeatable time frame, and that you have it documented so that you can prove that when the requests come through. Other legal obligations is meant to, make sure you're compliant with the EU legislation. So there are a number of obligations that are run in parallel to GDPR. So you really have to ensure that when you're looking at this entire list of what GDPR is, what do you have for any of the cookies laws, what do you have for any of the data handoff laws, any of the PCI. So think of all the audits that you do on a regular basis, work with your compliance and your legal divisions to walk through that. Recommendation would be to have a matrix so that you can put that in place. That matrix would then allow you to be referencing that as you go forward and as things change. Regular monitoring this is where we have a weekly meeting. So there's a meeting that walks through every component, walks through what our current status is, where we are with readiness, but then also goes through working with the legal team, the compliance team, has anything changed? And as we look at the business processes around the world, because remember, GDPR is the baseline for the new data policies around the world. And if you look at a number of other countries that are outside of the EU that are starting to follow these same processes, so you want to make sure you're thinking of this globally. So Japan has its new processes that are coming online. China has its processes. Australia has its processes. They're all starting to align with the GDPR regiment. So you need to think of it on a global basis, not just thinking I have 28 member states I need to focus on in the EU. Because you have the 47 that are part of the EU Council, and now you have the rest of the world that is there. And that includes looking at what are the other services that are available. So if you are doing business in the United States, all your capabilities in the United States, and you are doing business on a global basis, is going and looking, does Privacy Shield support you? Can you go register for Privacy Shield within the United States? Will that help you? So it's really making sure you're thinking of it from a U.S. standpoint for wherever you're processing. If you're processing outside of the U.S. but not in the EU, what are you doing? Really working with external counsel and working with centralized organizations that can help you manage through this. The next component is really, this is, kind of our view, but every company has an architectural outline of what they do. So when you think of it, when you put down where your company is, what does it do, what are the areas that it touches, each one of these areas contains PII data. Each one of these areas has data being ingested into it. So you need to think of your entire landscape of your company. And remember, it's not just digital data also. It is also paper data. There are a number of individuals that only correspond via the mail. So when you receive a letter from a European citizen or a different citizen requesting information, you have to have a process in place to manage through that. So there's just a number of checkpoints that you should be doing, and that's where you really need to think of this as a program so that you're looking at your entire landscape. And as you work with your M&A division, because they may be buying something or they may be divesting something, you're still responsible for that data until all those processes are handed off or managed through.
Great. Thank you so much, Thomas and Christopher. That was great. Let's get to some questions that have come in as you guys have been presenting. The first one we'll go to is, how have you managed to ensure that GDPR implementation at your company is not contained solely within the legal and compliance teams, but is a more company-wide initiative?
So this is Christopher. So basically, we've looked at this at a global level initiative. So this is really where I point back to the Y2K sort of model, is that this is a program. It goes across every segment of the company, and this walks through with all the senior leadership. So understanding, to Thomas's points earlier, this directly impacts your ability to do business in the EU. So it's really ensuring that the company understands that, the leadership understands that, your board understands that.
Great. We have another one here that came in. You mentioned that GDPR will be applicable from May 25th, 2018 on. Is there any sort of grace period?
I can take this one. This is Kerstin. So Thomas mentioned this already. The GDPR was approved by the European Parliament already in April 2016, and that was followed by a 2-year transition period that ends end of May this year. There's actually no further transition or grace period following that date. So additionally, it might be interesting to know that the GDPR is a regulation and not a directive. A directive would always require to be transferred into local law, but a regulation, this really applies directly across all member states. So it really applies from May 25th of this year on. There's no additional period.
Great, thank you. Next question, where should I go to get the facts on GDPR versus everyone's own personal view?
Well, I can take this one. This is Thomas again. The best place that I have found to find the raw data on the regulation is on the European Commission's website, which is ec.europa.eu. And then it has not only just the regulation itself, but it has a good list of FAQs that the data commissioners have answered, as well as a variety of other resources and external links that it then will provide you as well to give you guidance on how to best interpret the law based on the limited amount of information that is available today. There's likely after the 25th of May, there's likely to be additional information out there once you start to see regulatory actions and fines, penalties, and admonishments issued against corporations, and those will be available on the European Commission's website as well as on the individual data commissioner websites in their localized country.
Thomas. Another one that just came in here, how does GDPR apply to periodic database backup scenario and the right of being erased, i.e. a company processes personal data and maintains a daily backup, and then at some point in the future the customer makes a formal request to being erased. Does that need to be erased?
Yeah, so this is Christopher. So one thing that you need to make sure you have in place is your data retention policy. So when you think about your data retention policy, is why do you need to retain that data? So whatever that term may be, it could be 6 months, 12 months, 5 years, 10 years, because you have tax requirements, you have potential lawsuits. So this is where your company needs to define what its data retention period is. If an individual then sends in an electronic request, contacts your customer service, sends in a paper request saying that they would like to have their data erased, then you need to have your processes and procedures in place so you can respond back to them very directly that says that our company policy is 10 years, so your data will be deleted after we hit that 10-year period. So depending on whatever your data retention period is. So that's how you have to look through it on your process. If you're technologically set up to automatically delete data throughout your entire backups from your database, your recovery systems, within a period of time, you just need to evaluate that with your legal and compliance department to ensure that that's in alignment.
Okay, great. Next one, will we as a data controller be forced to move all our data falling under GDPR inside EU and delete all data that is stored in other countries? I've seen mentions that if user gives an explicit permission, we won't necessarily need to move the data.
Correct. So basically, for any processing that's done in or outside of the EU, you need to ensure that your policies and procedures, along with what's on your website or any processes that are happening outside of technology, state that your processing is happening outside of the EU. So the individual and the consumer understand that that's there. There's probably a request as to the protection and processes that you have in place. So there isn't a directive that says that you have to do all processing in the EU. Your processing can occur outside. You just have to ensure you have all the processes and procedures. So if there is a request that comes back from the EU, you'll have to make sure that you have those processes in place.
Perfect. Does Digital River consider themselves a data controller and or a data processor in their role as being the entity that takes the online customer subscription order and as the billing entity?
Yeah, so I'll take this one. This is Thomas Hamilton again. Digital River considers themselves to be an independent data controller. The reason that Digital River takes this stand is because Digital River is the first acquiring entity of the data from the end consumers. So Digital River, as merchant and seller of record, takes the data from the end consumer in order to process the order. And as a result, then we are the one that bills the online consumer as well as does all the direct interaction with them for purposes of the transaction. And as merchant and seller of record, then we have an independent data controller responsibility in that regard. Our clients, Digital River's clients, are also typically either can be classified as an independent data controller on their own or a data processor, depending on what they're going to be using the data for. And it's typically something that conversation is had between Digital River and clients and potential clients as to the interaction that the parties will each have with the data so as to establish what is the best working relationship. And one thing I'll just add there too is who is the data controller doesn't necessarily talk about generally who owns the data. Like data controller, if you're a processor, you can still have ownership rights to the data. As a controller, you can have ownership rights to the data. They're completely independent conversations of one another, and one doesn't necessarily tie to the other. So that would be one thing to keep in mind that I think there's a large amount of confusion in the marketplace about.
Great. Keep the questions coming, guys. This is going really great. The next question that came in was, what steps are being taken by Digital River to get ready for GDPR?
This is Christopher Rent. So Digital River has a full program. That full program has been in place for over a year, and literally that is managing, looking at every platform, looking at every internal component. So you would think of an enterprise-grade platform. You look at your internal services, anything to do with our CRM systems, anything to do with our employee data based on our infrastructure technologies. So literally the program is running that's done an evaluation of each one of the platforms, all of the data segments, how the data is being used, what are the data retention policies along with that data. So and that's what I stated earlier. It's a formal program that has a weekly review, and this is a weekly review that's gone up to senior leadership, and we continue to, as we work through, and it's managed if any issues arise. Basically, it's a program that we manage. So basically, it's my main focus along with our legal and compliance department.
Great. Could you provide some more insights on the consent requirement you mentioned and the impact?
So I can take this one. This is Kerstin. So as a general rule, every use of personal data requires a lawful basis, and that could be different. So that could be, for example, a contractual purpose or something that is required to comply with the legal obligation. It could also be consent. The GDPR is pretty clear on this certain requirement of consent. It says that consent must be unambiguous, prominent, concise, and easy to understand. So this means that there needs to be a positive action, which would exclude an opt-out checkbox, but would require an opt-in consent. for Digital River, we in the past have already relied in certain circumstances. For example, when it comes to receive of a newsletter, we already relied on opt-in consent. Right now, we are looking on every single use case where we used consent and try to check and figure out if this would also still comply with GDPR.
Great. Is there a legal way to ensure that users demanding the personal data be deleted or changed is really the given subject of personal data?
Yeah, this is Thomas Hamilton. I'll take that one. Typically, what you do is when an end consumer calls in to ask for their personal data be deleted or changed, you ask questions that are information that you retained when you did the commerce flow. So, for example, when they did the transaction, they'll be providing certain data points and personal information that may not be just the information that's publicly available. And so you can ask for stuff such as order numbers, or you can ask for information such as postal code, or where you have the transaction, you can have them implement security questions. It says what city was the city in which you were born, what city, what was the road you were on when you were in primary school, or something to that regard, whereby you can have it so that you have that verification that the individual is in fact that individual requesting the change and deletion of data. So typically you want to stay away from questions that are typically publicly available information, such as name, address, postal code. You want to have something that is less likely to be something that's publicly available that somebody could have gotten either through some sort of illicit means or could just find via public record. So taking information such as order number, or asking, hey, what did you buy? Can you recall what item you purchased? And then that will give you the information to ensure that that person is in fact the individual being requesting the information. So.
Perfect. Let's assume that a company is an SMB and does not have the resources available to pay an external auditor to check for GDPR compliance. What steps can be taken here? Judging by the presentation, the focus of the webinar is for enterprise. Thanks.
This is Christopher. So yeah, from an SMB or another an independent company, if they need to look at this, it's really going out to the GDPR sites. There is a checklist that you can walk through. So it's really walking through the general pieces that go along with it are understanding all the divisions of your company, even if you're a small one. Who are your suppliers? And how are they using data? Who are the third parties that you're tied to? So literally this can be a detailed checklist, but what you need to prove is that you have a program. And that program has been put into place, and that could just be the one person that you have that literally is documenting this. So when you do have a request, or if something does come up from the European SA requesting this information, you have a process that says that you have identified the data that you're using, you've identified the reason that you're retaining that data, the reason that you're using that data, and you have processes and procedures in place on how to address requests from consumers. So it's, it really does come down to a detailed checklist and a program.
Great. Is there a set timeline for how fast a company needs to respond to an end user data's request?
This is Thomas again. I can take this one. So there isn't a set prescribed time frame. What it does is it uses the vague terms of as expeditiously as possible, but in a manner in which you no longer need and require usage of the data. So you want to have a process by which, if you no longer need or require the data, that you have a manner in which to handle it promptly. Typically, if it's in a couple 24 hours, 72 hours, it won't be an issue. It should be what they consider to be done in an expeditious manner. The other guidance is if you need it for a legal regulatory manner and need to retain certain parts of the data, then you don't need to either delete the entire data set. You can retain the data set that you need in order to adhere to those requirements and your other legal obligations. Or you can retain, if you need to retain the entire data set, you can take the request, process the request in an expeditious manner, and not necessarily delete the data immediately, but have it on file so that the data is deleted when it is no longer necessary to have in your possession.
How do I know I have data subjects that are in scope of GDPR?
So this is Christopher. So any individual that is a European citizen any individual that's in the 28 member states. So these are some of the points that you have to think about is if you don't know your consumer, then you need to use your processes to understand where they're coming from. So it's working with your logistics group to understand where physical products or any sort of mailing content was sent to. If you have the capability from a digital standpoint, is where was the original GeoIP? So when the individual logged onto your site with GeoIP, understanding where that's coming from. So those are the items that you need to, part of your checklist to understand where your users are coming from, and along with that, understanding the user type. So, is it an individual? Is it a child? Being able to segregate out that data.
Great. Getting some questions on whether or not you guys will receive these slides. You will be getting a recording of the full presentation, so yes, those will be coming over after we wrap up the webinar. Another question, is there standard legalese to use for business contracts to reference GDPR?
I can take this one. It's Thomas again. There's what's called standard contractual clauses, which are standard contractual language that the European Commission has established. They established them back with EU Directive 9546, so they're not necessarily something new. They've been around for a while. There's also what is known as binding corporate resolutions that can be established, as well as the replacement for the safe harbor, what's known as the privacy shield for U.S. companies to establish adequate security measures and to outline it to the European Commission. But the contractual ways, those standard contractual clauses that have been around for the past 20 plus years, they are being refined and enhanced as a result of GDPR. There will be changes to them, and companies are likely best to implement a procedure to review their standard contractual clauses that they've used in the past, see what changes need to be made, and to revise them in anticipation of GDPR prior to the 25th of May. But it's something that is going to be the standard framework that's been used over the last 20-some years.
Perfect. Okay. The name and the surname of the user does not necessarily lead to the given subject of personal data. Is there a need to notify the subject of a personal data if those parameters have leaked during a data breach?
This is Christopher. So the name and surname are PII. So if you think of everything that makes up an individual, so those are PII data elements. So when you look at, you had a incident, so you've developed all the impact from that incident. You've decided to define a breach. So that data was subject to public availability in one way or another, hard copy or electronic. So yes, that will need to be in scope, even though that individual's, a surname is not tied there. But if someone can take that information along with other publicly available information to identify that individual, that is, the way that you need to account for that and make that a part of the notification process.
Great. How will I know if I'm compliant?
So this is Christopher. The compliance is based on making sure you have all of your data pieces. So if you look at GDPR and you go through what are the standards that are defined within the regulation and the associated articles, to ensure that you've identified, you have your policies in place, you've identified all the data that's coming into your system, you understand how that data is being used, and you can articulate it, because those are where the questions come in, that if the supervisory authority comes back to you and says, we have a complaint, then you need to be able to sit down with them and show them exactly how their data is being used, how you're retaining it, what are your policies that are along with it, how are you destroying it, and even if you are retaining that data and you're anonymizing it. So then that data means it's fully anonymized and can't be used, but you have to have that articulated, you have to have the policies in place. So there isn't a seal of approval that gets stuck on your website that says I'm GDPR compliant. It means that you've followed all of the guidelines within the regulation and that you can answer any of the challenges that may be put forth.
Great. We use Digital River as part of our e-commerce system. If one of our customers requests for an order-related data or requests personal data to be deleted, what process will need to be followed to get this processed by Digital River?
So I can take that one. This is Thomas again. So we have a tool called Privacy Tracker, in which we log all requests from end consumers as well as clients, once clients have received and then taken from the end consumer themselves because they've directly contacted the client or the manufacturer of the product first prior to Digital River, not realizing Digital River's role as merchant and seller of record, and then they can communicate back to us either through the email or other means by which to say we have an email called Digital River Compliance. We also have an email called privacy@digitalriver.com, and either one of those emails then we can take it and implement in the tracker if there's not access to the tracker directly by the particular client, or they are unaware of how to use the tools themselves, and we can take care of the request and process it to ensure that it's handled on both ends. And similarly, if we receive a data deletion request from an end consumer, we also pass that information on to the client through the same tools so that the client has it so they are aware of the request to delete data of a particular end consumer in case information was passed along to the manufacturer of the product for purposes of subscription management or the like.
Okay, and I think this is another one for you, Thomas. What do you think the first GDPR enforcement action will look like? For example, will the European authorities levy fines or just send warnings?
So that's a good question and a loaded question. The answer for that right now is entirely unknown. The guidance has not necessarily been clear as to what the European Commission and the officers and the commissioners of the individual member states will be looking towards. Once again, it's self-funded, so I think that's something to keep in mind, in that they're not going to be able to have a payroll unless they start levying fines. Typically, under the institution of when they did the data protection directive, the member states, because they were managing on their own, typically gave warnings first before doing fines for the most part. Some states did actually start with just fines. But it's likely here that they're going to try to make an example of one or two people. The general view that I've gotten in conferences that I've attended on the topic is they've given 2 years of time of ready, in time frame in which to make companies, enable companies to get ready, and companies should be using that time frame to get ready, and the expectation is on day one you are ready. So it's likely they're going to make an example of one by instituting a fine on an organization early on, probably in June or early July, but then they may also issue other admonishments and demands to have practices remedied before levying a fine as well. So it's still the great unknown at this point.
And this is Christopher. Just to add on to that, just so everybody's fully aware, is that your errors and omission insurance does not support the fine. So if you are levied a fine under GDPR from the EU, you cannot use your insurance to pay that fine. That fine is something that is paid from your company. So these are the things that you need to ensure that you have funding in your forecast or some sort of set aside that your company understands that if they were levied a fine, that they would have to make that payment out of funds, not from an insurance payment, insurance policy.
Okay, next question. In reference to the data protection officer, can you give any context on what threshold the Commission will use to interpret systematic data monitoring on a large scale? Is that 100 customers, a million? How do I know if I'm required to hire a DPO?
All right, so there is not a threshold scale within GDPR that says that, if you have 100 customers, you need to have a DPO. What you do need to do is you don't need to hire a DPO, you need to appoint a DPO. So if you are a small company, you can appoint even someone in your legal team, some of your compliance team, one of the operational component of data. These are the individuals that will be called upon to say that, yes, we have policies and procedures in place. They understand the data flows as to how your company is using data, how it's managing it, how it's destroying it. So it doesn't have to be an individual that you're going out and hiring. What the GDPR does look at is that they recommend that this would be somebody that's in the EU or somebody that has EU citizenship or dual citizenship to understand that. But there are U.S. companies that have assigned DPOs, so Federal Reserve Bank, the Commerce Department of the U.S. government, a number of other large companies that are only based in the United States that have just assigned a DPO, which is an individual that understands the data flows, understands the policies, the procedures, and works closely with the legal departments.
Okay. If terms and regulations that the user has agreed on state that I will store personal data for 5 years, is it enough for me to store data for exactly 5 years, even if the user demands the deletion of the personal data?
So this is Thomas again. I can take that one. There's not an absolute right to deletion in the regulation. The key thing to keep in mind is that there are a handful of exceptions in Article 17 for possessing data. And one of the things is that, as we stated before too, you have a right to retain data if you have a legal obligation to do so for some other purpose. So as long as you can justify that you are retaining the data for that purpose, you may still get an enforcement action from the European Commission that you have to defend, unfortunately, but it's likely that you will have, as long as you have robust defenses as to why you've retained it for that 5-year time period, then you will be able to defend the right to the reason why you've had it under that exception in Article 17. Keep in mind that as of now, because there have been no enforcement actions yet to date, nobody knows really how that will be handled, how they will receive that. But it's typically standard industry practice to manage the data and the requests in that way.
Okay. GDPR applies to personal data of data subjects based on their EU presence, even temporary. You have a system that creates users' accounts. Is it technically practical and reliable to figure out the subscriber's location at the time without asking?
Yes, so technologically, it depends on your system, but if they're logging onto a website, you can track their geolocation. So if they are in Dusseldorf and they're logging on and they're only there temporarily, it could just be a U.S. citizen that's, they're purchasing some product off your site, then that information based on what you've tracked, or an EU citizen, or it's just any data subject. So using what you have for geolocation, what you're doing for the shipping information. So there literally is a process, the processes that you have to be able to do that. If you don't have any technical or business process to understand if the individual is an EU citizen or a data subject, you just need to define that in your policy, because you may have people that do mail order and may ship something to a U.S. address, but they may be a EU citizen in the EU doing that. So you just have to have the policies and procedures so that if the questions arise, that you're able to say, I cannot, within any business technology I have, assess if that is an EU data subject.
Okay. Does the U.S. federal government support or oppose GDPR as a potentially having a substantial impact on U.S. business where EU companies going the other way have no such impact, having to protect U.S. citizens of the U.S. and their personal data?
So this is Thomas. I can take that one again. It depends on which administration. I would say that you have the U.S. Commerce Department, who's invested more in ensuring that businesses that operate and are headquartered in the United States have a means in which to continue doing business in the European Union and their member states. So their real investment is making sure that that U.S. commerce and ability to offer U.S. services and goods into the EU continue, rather than do they have a means of whether they oppose or are they in favor of it. I don't think there's been really any direct opposition to it. I don't think they find it as something that is favorable for U.S. companies generally. At the same point in time, the U.S. Department of Commerce hasn't necessarily wanted to take on a regime whereby an insulary protective regime whereby we create our own regulations that counteract it. I see Canada as being more likely to do that than the United States, but the United States will try to keep it so that data can be used by businesses on a commercial basis as much as possible.
Great. I want to thank everybody for your participation and all of the questions that came in. It certainly created some great conversation. We are going to wrap things up here. We want to thank you for joining the Digital River team. Again, we will be sending out a copy of the recording, and we look forward to working with you in the future. Thanks, everybody.
Ladies and gentlemen, that does conclude the webcast. Are you ready for GDPR? We thank you for your participation and ask that you please disconnect your line.